Hello friends, welcome to Exam Tricks. This is Mangla Pandey and today we will be discussing Article 18, Abolition of Titles, and with this we will be done with our Right to Equality series, and after this in the next video I will discuss the kinds of questions which could come from this section as well as how to attempt these questions. But before that, let us complete Article 18. Article 18 deals with abolition of titles. In the past, we all know that the British government used to confer titles such as Rai Sahab, Raja Bahadur, Diwan Sahab, and it was believed that it was done with kinds of ulterior motives to gain individual loyalties from the people to which it conferred the titles. It was a kind of discriminatory practice and clear abuse of power. Therefore, to prevent it, the Constituent Assembly incorporated Article 18. Article 18 prohibits the state from conferring any kind of titles as well as it abolishes the titles conferred before independence. But now the question arises, if Article 18 prohibits such kind of conferring the titles, then why awards such as Bharat Ratna, Padma Bhushan are given? To understand this, we will have to first understand the background of this article. During the primary discussion on fundamental rights, K.T. Shah advocated very passionately on the abolition of titles, honors, distinctions and privileges. When it went to the advisory committee, it was decided that states should award titles to provide recognition and incentives to those who rendered social services. Patel also wanted to prohibit only future grants of titles, as he thought that disturbing any titles granted prior to independence would create spiteful instances. Finally, in the Constituent Assembly, it was decided that Article 18 not only would prohibit the future conferment of the titles, but would also provide for the abolition of titles already conferred on individuals by the imperial government. There are 4 provisions of Article 18, and Article 18(1) of the Constitution makes it explicitly clear that military and academic distinctions would form exemptions to the general rule that titles are not to be conferred by the state, and therefore awards like Mahavir Chakra or Paramvir Chakra are not void and are validly permissible within the constitutional limits of Article 18(1). But remember that Bharat Ratna and other such state awards are not placed under these academic awards, and to understand distinction, we need to first understand the differences between the academic and distinction, the difference between these two words. D.D. Basu defines titles as something that hangs to one's name as an appendage. For example, prior to independence, those who were conferred the title of Rai Bahadur, Rai Sahab, these titles were written along with their name and it would carry along with their name, while the dictionary meaning of the title includes descriptive designation, which means that it clearly makes them superior to the common citizen. However, academic and distinctions are related to something scholarly, classical, literary rather than technical, and it is a distinguishing mark of quality, a mark of honor, and these kinds of academic distinctions are not considered as titles because these distinctions are acquired or conferred according to the set academic standards by such institutions which have a promotional interest in academic learnings. Therefore, there were no such criteria for granting titles, while for granting academic titles there are set fixed criteria. But in 1958, the Government of India introduced the titles. These awards are classified into 4 categories. We all know Bharat Ratna, Padma Vibhushan, Padma Bhushan and Padma Shri. Argument which was given was that since these decorations are not to be used as appendage to names of the recipients, these cannot be deemed titles within the meaning of Article 18(1) of the Constitution, which means that if somebody is conferred Padma Shri or Padma Bhushan or Bharat Ratna, it should not be used in their names. But we all know the practice is totally different. The Janata Party government headed by Morarji Desai discontinued them in 1977, but again when Indira Gandhi came back to the power in 1980, she again revived this. In 1996, Supreme Court also upheld the constitutional validity of these awards and ruled that these titles do not come within the ambit of Article 18(1). However, it also ruled that they should not be used as suffixes or prefixes to the names of awardees. Otherwise, they should forfeit the awards. Thus, although the constitutional validity of these titles has been upheld by the Supreme Court, but many questions have been raised about these awards. What are these questions and why are these questions are raised? These questions are raised because there is a complete absence of transparency how these awards are granted, what is the criteria for shortlisting the candidates for granting the award. Sometimes totally unknown persons are given these awards. Second, it causes discrimination. Although it says that it is not a title, but it creates not only a distinction among the citizens, but also the different kinds of awards are given. It creates a different kind of distinction among the awardees. Third, title holders also enjoy certain privileges as they are given ranks beneath the cabinet ministers. Therefore they enjoy certain privileges, and it in a way negates Article 18. And finally, we all know, due to growing politicization, who will get the award is totally a matter of politics. Although Article 18 has not been much popular among the examiners, but I think with the recent debates going on the granting of these awards, we must not risk and we should understand the basics. Therefore, I have discussed Article 18(1) in details. Let us move forward to Article 18(2). Article 18(2) provides that no citizen of India shall accept any title from any foreign state. For example, if any foreign country awards certain title to Indian citizen, they are not eligible to accept it without the consent of the Indian government. For example, Gavaskar was not allowed to accept the knighthood when he was given so. And not only Indian citizens, but also those non-Indians who are holding any office of profit or trust in India are not allowed to accept any title or any kind of favors without the consent of the president. And this provision has been provided in Article 18(3), which says that no person who is not a citizen of India shall, while he holds any office of profit or trust under the state, accept without the consent of the president any title from any foreign state. And finally, Article 18(4) provides that those person who holds office in the country will not accept any emolument or office or any kind of favors or titles without the consent of the president from the foreign state. Finally, to conclude Article 18, we can understand its four provisions. First, that it prohibits the state from conferring any title. Second, it prohibits a citizen of India from accepting any title from any foreign state. Third, it prevents a foreigner holding any office of profit in India to accept any title or favor or emolument from the foreign state without the consent of the president. And finally, no citizen or foreigner holding any office of profit or trust under the state is to accept any present or emolument without the consent of the president. Therefore, it not only bars the state but also the citizens, non-citizens, as well as the officers who are holding office, those who are either citizens or non-citizens. With this, we are done with our Article 18, and along with this, we are done with our Right Equality series. I hope you like this video. Feel free to comment and give any kind of feedback or suggestion. Till then, subscribe to my channel.